wa Njoro. Kumbuka hapa ndipo unajifunza mambo mengi kuhusu ukulima. Kilimo ni uti wa mgongo wa nchi, na ukiwa na Njoro unajifunza. Kumbuka, angalia mwenyewe. Tunakuambia ukitaka kujua tips za ukulima, ungana na sisi kwenye Lookup TV. Every Sunday unatukuta pale saa 10, tunakuonesha kuhusu ukulima. Ukulima wa mimea, ukulima wa ng'ombe, ukulima wa kuku, ukulima wa mbuzi na yote ambayo yanahusiana na ukulima. Kumbuka nini? Kipindi ni Ukulima ni Mali.
Taarifa zinapochipuka na kutufikia papa hapa kwenye makao makuu ya chumba cha habari cha runinga ya Lookup, kwenye taifa, kwenye serikali, kwenye bunge, tunajitosa hadi kwenye sauti ya wenyeji ili kupata tu maoni ya wenyeji kuhusu masuala haya yanayochipuka.
Maana hii kitu inaenda kuumiza Mkenya kwa tax.
Hakuna kitu tunafurahia. Nothing. Absolutely nothing.
Sisi tunaumia. Si ati tunaumia ile ya kiukweli. Juu maisha ni ngumu.
Na bila shaka tunapata maoni yao ili sauti yao ipate kusikika. Na watasema hili, waseme lile, watasema hiki na waseme kile, almuradi sauti yao ipate taa.
Mambo ya mafuta tena imekuwa ni changamoto zaidi kwa kila mtu wa bodaboda.
Hawa sasa ndio wamefinywa zaidi mazi.
Penzi mtazamaji, hii ni bunge la wenyeji.
Feeling like unwinding and calming your nerves down after a long week? I'm Nick Akala. Join me on the Nakala Report this coming Friday and every Friday at 8 p.m. only on Lookup TV. At Nakala Report, we turn the insanity into sanity and sanity into insanity.
And now, welcome back. I'd promised you that we'll be having a conversation indeed to understand the clear state of inheritance and succession right in the country. And of course, perhaps we also need to understand where the law lies and the constitution as far as inheritance and succession is concerned. By the way, we are having a conversation now with the lawyer. Cecilia will be helping us to understand really and clearly the context of law as far as inheritance and succession is concerned. Allow me to read one of the lines here. Testate versus intestate succession. Now, testate succession, if someone dies with a valid will, testate succession, the estate is distributed according to the instructions outlined in the will. Intestate succession, now, if someone dies without a will, in testate succession, the Law of Succession Act provides a clear structure for distribution, prioritizing the deceased surviving spouse, children, and other dependents. Now, you've heard the story, of course, of the two sisters, and of course they've shared to us their story, but now that was early 90s. What is your take on the law of succession as far as to the early 90s is concerned?
Thank you so much, Moses, for that question. Now, the fact that this happened in the early 90s does not bring any substantial question as to the laws that were applicable then and those that apply contemporarily. Why is that so? Because the Law of Succession Act, the one we were using in the 1990s, is still the same one that we are using even today. The Law of Succession Act, there is no difference. The act that we are using now, the Law of Succession Act, Cap 160 of the laws of Kenya, came into force in 1981. 1st July 1981. So as you can see, 1990s is actually 10 years since it had come into place, and it was already the applicable law at the time. There may be discrepancies as per maybe with the coming in of the new constitution, but that doesn't change a lot because the new constitution, the one we have promulgated in 2010, only emphasizes on the right of equality of the children, that they are all equal before the law, be it that they are male or female. So yeah, that's the new aspect. But even with then, the Law of Succession Act cared for all children. Yes.
Wonderful. And of course, you've mentioned something on equality of inheritance, which the Act ensures that the children, regardless of whether they were born in or out of wedlock, have equal rights to inherit from their parents' estate. What is the clash in all these? Whereas now we find that there is a sense of bargain between who should own this and who should own that. With the view of the country right now, the elder brother or the elder sister will complain much and says that I am supposed to own this particular property is also that a conversation of equality for inheritance and to inheritance.
Thank you. Mostly such a question arises in intestate succession, where the deceased or the owner of the estate died without a valid will or died simply without a will. You've said that the children, as defined in Section 35 of the Law of Succession Act, means even those born out of wedlock. But the scope is even bigger because it means even the adopted children. So the Law of Succession was really a game changer in this aspect, and this is where it has slight discrepancies with the customary law, which the customary law still also validly applies, and this is where we mostly find what you are talking about of we as Africans, or in most of our communities, viewing that, for example, the eldest child is the one who should take the biggest share of the property or be the one in charge. Yeah, this still happens in intestate succession, only that this is now more governed with the law. You find that the eldest child in an intestate succession can be the one who applies for the letters of administration of property. We call them the grant of letters of administration. Yes.
All right, and of course to mention as well, we had actually started with the equality thing, which of course I'm also eager to understand the gender equality. If so many of the offsprings were girls, is that also a proportion to of consideration?
This matter was put to it's called Rono versus Rono and another, where the court pronounced itself very clearly that all children are equal. And the property of the deceased or the estate of the deceased should be shared equally among all children, regardless of the gender. And this just reflects what is provided for in the Law of Succession Act. Only that know this, but also the practice in our courts and as reflected by jurisprudence is that customary law can only be applied up to the extent that it is still consistent with the law, that is with the constitution and with the statutes. When it is inconsistent with such law, it is no longer applicable. True. So when it discriminates against one gender, it is not applicable.
But still in the same context, we have a family that has so many girls with only one male child in that particular family. How will we handle that equality?
In such a case, the Law of Succession Act is very clear that the property is to be divided equally among all the children. Now, there's also the aspect of the spouse of the deceased. Let's say the man who died. The spouse gains what we call a life interest in the property of the deceased, such that she has ownership of the property, she can use it, but she cannot sell it.
Indeed.
Yeah, so she owns the property but cannot do such things until when she dies or the children are of age, and now she voluntarily transfers the ownership to the children. Now, there's a different case if it is a tested succession where the deceased had a will, because if the deceased had a will, he can proportionate and give proportionate shares of the property and say maybe my eldest son will get 25%, my daughter Nani will get 13%, my son Nani will get the apartment in A, B, C, D. That happens in tested succession. But now in intestate succession, equality and other principles of the law must be considered.
Help our viewers to understand the difference between now ownership and succession as far as the law is concerned, and what are the basis of consideration when we speak about now this is what our parents left us and this is what we need now to have as our inheritance. Help us understand the difference between all this according to law.
Yeah. In such a regard, first you've said the difference between ownership and succession.
Indeed.
Ownership in this context actually means that the deceased before his death he owned all this property. All this property was in his name. But now we have a deceased who has dependents. Section 35 defines the dependents, and that's where it defines all children, whether born inside wedlock, outside wedlock, those adopted, and the spouse. Now, as we have said, after the death of the deceased, the spouse gains what we call life interest in the property, such that all the property first transfers to the spouse. But what are the things that the spouse can do? The spouse can only administer the property and hold them in trust for the dependents, in this context, the children. Now, with time, the spouse can decide to legally transfer the ownership of this property to the children and have them registered in their own names. And of course, this can only be done if there is agreement between the children and the surviving spouse, or this can work until the time when this other spouse also dies, such that only the children now remain. If the children are the ones who remain only and there is no will, then the property will be divided equally among them, such that if the property is worth 100 million and the children are 4, each should get 25 million. That is equal. That is not equity. We have not gone to equity, but the law is very clear. The youngest should get the same with the oldest. The law is very clear on that.
That is where we have a problem, because they feel like the elder son needs to get a bigger proportion rather than the youngest. And the same crisis is facing the country. Of course, it's a crisis of land ownership marked by inequitable distribution, historical injustice, which I believe it's the same thing that is affecting the two ladies, and land grabbing and disputes, with many Kenyans lacking secure tenure and access to land. Colonial land policies and subsequent mismanagement have accelerated these issues, leading to conflict and social and problem of land succession and land inheritance right in the country will be sorted as far as the law is concerned.
The issue of land ownership first in this country, and it's a very emotive issue. It's very emotive, such that when it is talked about, people become very emotive and people get emotions, because we are sentimentally attached to land. Indeed. And that's why people kill each other over land. People break family ties. Now, that means that land is hotly contested, even where dependents of a deceased person inherit it. As you have clearly stated, there has been a very big conflict between what our laws provide and what most of the surviving generations believe in, because most of our generations believe, for example, that it is upon the eldest child of the deceased to get the lion's share of the property, or maybe in some communities, even in Kenya, they say that the female child should not inherit property, with a very logical reason, in that context, that she will be married elsewhere and she will inherit the property in that other place. But this is not what is provided for in our laws.
What is the confusion about all this?
The confusion is that what people believe in and what is largely practiced in our customary laws is different from what our laws provide, because our laws insist on equality.
Indeed. And
whether you are learned, whether you are not learned, whether you are the youngest, whether you are the oldest, whether you have been married elsewhere. And this was even settled in the case of the estate of Lorenkai Olentutu, 2008 case. I think one of the governors in Kenya today, who I will not mention, belongs to that family. And the argument was that their sisters had been married elsewhere.
Indeed.
And there was no need for them to inherit the property that had been left by their father. But their sisters were very adamant and they were very tenacious with their rights as provided for in the Law of Succession Act, that they should be treated equally, and as had been decided in the case of Rono versus Rono. And therefore they were very tenacious and determined, and the court agreed with them that let the property be divided equally. Still with that in place, and with our laws being very clear, and even the jurisprudence in terms of what the judges have decided over the years, you find that culture is very much rooted in us.
Indeed.
And most of us take it very, very seriously and critically. So that's why you find that there are cases where in communities, ladies themselves, they don't contest the property. They say, no, for me, I've been married elsewhere. I don't want this property. Let me leave it to my brothers. Or maybe someone excludes himself, says that, in this family we are 6, but for me, I've at least made something for my life. Or my father educated me. Now I have a big position somewhere. I can buy land for myself. I have bought property for myself. So this one, I can leave it to you,
of course,
who are struggling maybe in economically or financially. That happens, and when there is consent, there is no problem.
And to speak about that, there is so much elevation as far as land ownership is concerned right in the country. And here we've seen the development of affordable housing, and people accumulating bigger portions of land just to create a space for the long-term investment. We've also seen that, and I believe also the crisis comes in when we deliberate on who to access this land, who to own this particular land, so as to have a bigger space. Will you talk to us about the title deeds? In the space of now, this document is so much important. Yes, you are supposed to be the rightful owner to this particular land, but you don't have documents to prove that.
Thank you again for that question. As I'd start by saying, as I've mentioned earlier, the issue of land is very emotive, and that's why the Constitution of Kenya 2010, Kenyans saw it fit that let our whole chapter of the Constitution be dedicated to land matters, and that is chapter 5 of our Constitution. It solely talks about land and environment. That tells you how serious this thing is. And in furtherance of chapter 5 of the Constitution, we have the Land Act of 2012 and the Land Registration Act, which govern the disposition of land and its use and everything. Now, you've said how there's confusion about land and how people are scrambling about it. People have realized how much value it is worth more. So if it's in a prime place or in an urban area where we are having projects like the affordable housing. Just the other day I had a client who came to me and was telling me that there's an investor who wants to buy land from his mother to develop the land. The land is in Ngara and around Pangani there. And the investor was like, these are prime land, you people are wasting it. We can develop this property and make it be of much higher value. And I think the case in the same, even where I live in this Nairobi, the value of land is very much high, but you still find there's land that is lying idle, or as an investor would feel the people are not utilizing it to its fullest. There are laws governing that, and I will not enter into that. But what you have asked about title deeds and such, number one, as per the Evidence Act, title deed is a conclusive proof of ownership of land.
Indeed.
And the fact that if I present to you as Moses a title deed, you would believe that this land therefore belongs to me. But still, there are people who own land this land was either inherited to them or they got it by any other means, but they don't have title deeds.
Indeed.
That's why we've seen the president sometimes going around and giving title deeds himself. We've seen this at the coast. We've seen it in some areas here in Nairobi. We've seen it even with the minority communities or even those who are settled in by President Moi in the former regime.
Indeed.
Yeah, so land is really of value, and with the recent developments, and in fact there was contestation about the affordable housing when it came to realization of Kenyans that a good number of a good size of land where affordable housing is constructed, and mostly in Nairobi, is owned actually by private citizens. It's not owned by the government. This may be contrary to what they had been told when this project was beginning, that the government would acquire land where such a property would be developed. And you see, if affordable housing, a government project, is already done on a private land, that brings the other legal issues of maybe joint venture, trust or something. So still, we really, this still a gray area in our laws, and not that we don't have much laws about it, it's only that people are very much woke to this this matter of land, and even people with the deep pockets are ready to do anything to even secure some land or have it developed.
Who should be blamed when there is no title deed delivered to the offsprings of that particular family, and there is no context of debate between who now needs to have this particular documents? So who should be blamed above all?
First of all, the contexts are different, so we can't really apportion blame to one person, because some of these situations you find that maybe these lands have histories.
Indeed.
You find that this land was maybe given to someone's grandfather after maybe fighting for the country or fighting for the British government in World War. You find that, for example, the Nubians, I saw that there was recently an issue with their land and their settlement. For example, the Nubians were settled by the British after fighting for them in the Second World War. You find that there is land that was given by President Moi, and in the former constitution this was very much legal. Allotment, it's called allotment. The president would just reward you with land or say that this community, we are going to give you land there. And most of at that time, it was only enough that the president has said and has announced, whether on the roadside or where, the President Moise has said that this land is yours, then it would belong to you. And maybe at that time, someone wouldn't really care about title deed. But now, with the advent of cartels and such contestation, is when someone realizes that kumbe title deed is this much important, then I should arm myself with it. So you can't really apportion blame to one party because of the different contexts of this land, because I'm also aware
the parents also should consider that before they
yes, I'm coming to that on mostly customarily inherited land. I am aware of a number of situations where land has been customarily inherited, but still they don't have title deed. Though I think with the knowledge of recent happenings in the country, most of the families have really rushed to the relevant authorities and have received title deeds. Now the thing is, the body that Kenyans or anyone who owns land but doesn't have a title, they should start at the office of the Registrar of Lands. It's very much the office is very much established as per the Land Act.
Allow me to ask you, Cecile, about now the concluding factor in all this conversation. Yes. That if someone now has been found in this challenge and now wants to project his voice or her voice in the law, or as far as constitution is concerned, and needs to seek a lawyer and needs to address their matters as far as the inheritance and succession is concerned, what can be done?
Thank you so much for this question. I think most people, when such matters occur between them, they go the litigation way. Indeed. That is to approach the court. And the best when more so when contesting about these big portions of land or property is to go to the High Court and petition the High Court, because the High Court has really expanded its locus standi in our new constitution. Article 165 is very clear that every Kenyan can bring a case before the High Court. Every Kenyan, and even these other courts, the magistrates courts, you can institute a court proceeding there.
If it is
but
not working?
if it is, if the value of the property is more than 20 million, then you just institute it at the High Court direct. But we are at a point in time where these land matters really take long before the courts, and there's backlog of cases in our courts. So what is advised in the current times is that let the contestants try to find a solution within themselves first, because even if you go to court, the court first gives you a chance to settle the matter between yourself, maybe through mediation, negotiation, or arbitration. If that fails, then now you got the litigation way.
All right, thank you so much. Very wise words from you, Cecile. Thank you so much for your time. You are an honorable lawyer, right? Thank you so much. I think our watu watakutafuta. If it's not possible, of course, waanze kulipa tu rent.
I can give them my contact.
Kabisa. Haina wasiwasi. All right, ladies and gentlemen, we've been having a conversation on inheritance and succession, and Cecile has elaborated for us clearly what is supposed to be done after all these things. We're having the challenge as well. What is supposed to be done, and of course it's litigation or the other way around. But I believe you've also understood the context on the will, the title deed, and perhaps what the law and the constitution says above all. That is all for today. Remember, it is a conversation on Thursday, and of course we've embraced the two ladies in understanding the context in the law, and they've shared to us their stories. But above all, let the law abide. This is the Morning Drift. See you on Friday. My name is Moses Okech. Thank you so much.